Regents of the University of California. One was a leading case in California that established a persuasive six-factor test that helps guide courts to decide when a contract relates to the public interest. Specifically, California courts had a history of holding exculpatory liability waivers within contracts to be valid only if they did not involve the public interest. At the time, it was difficult to gauge exactly what the courts meant by interpreting this statute to apply fervently to contracts in the public interest. Tunkl helped clarify this, though there is still a debate as to how many of the six factors must be met, or whether certain factors should be read to be subservient to others. According to Tunkl, the six factors that determine, in the instance, whether a contract relates to the public interest are: 1. The party seeking exculpation is engaged in performing a service of great importance to the public, which is often a matter of practical necessity for some members of the public. 2. The party holds himself out as willing to perform this service for any member of the public who seeks it, or at least for any member coming within certain established standards. 3. As a result of the essential nature of the service, in the economic setting of the transaction, the party invoking exculpation possesses a decisive advantage of bargaining strength against any member of the public who seeks his services. 4. In exercising a superior bargaining power, the party confronts the public with a standardized adhesion contract of exculpation, and makes no provision whereby a purchaser may pay additional reasonable fees and obtain protection against negligence. 6. Finally, as a result of the transaction, the person or property of the purchaser is placed under the control of the seller, subject to the risk of carelessness by the seller or his agents. If a contract both meets these factors and includes liability waivers, it may be held to be invalid and unenforceable as a matter of law and policy.